Hey everyone, today's lecture is going to be on civil liberties. This will correspond to chapter 4 in your book, so let's get going. So first of all, what are civil liberties? What are we talking about here? This is maybe a term that's come up a few times in prior lectures. Just to reiterate though, these are going to be really the core rights and freedoms like freedom of speech, assembly, religion, things like this that the government is there and obliged to protect. According to the Founding Fathers, protection of these core rights was the fundamental purpose of government. It was its highest calling, the reason we have it there. In this lecture, we're first of all going to be talking about where these liberties are in the Constitution, some history about their application to either the federal government or state governments, which changes as you go through time. And then following this discussion, we're going to be talking about some specific civil liberties like speech, religion, criminal procedure, and get into detail about what the Constitution and the Bill of Rights say about these liberties and how the courts have interpreted and applied them as we go throughout the nation's history. Alright, so first of all, let's get back to talking about the Constitution. This has obviously been a frequent topic in our past lectures on the Constitution and federalism. It's just as important when we're talking about civil liberties. So first of all, like we said, civil liberties, these are the core rights that the government must protect. Examples like freedom of speech, freedom to worship as you please, freedom for the press to publish what it wants, things like this. A key aspect of civil liberties, as if we're thinking of them as policies, is they're largely defined by the judiciary. So Congress doesn't really pass legislation outlining the limits of freedom of speech or religion or whatnot. It's mostly the courts that are left to decide how far these liberties extend. And in a general sense, they're held in high esteem and protected, but in some cases, government does have reason to restrict them. Oftentimes, in times of crisis, when there's some really important goal that necessitates restriction of liberties, there are cases when the American public has been okay with this. Most notably, in times of war, if there's fear that saying certain things or publishing certain things might harm public safety, or the effort to end the conflict successfully in our favor. These have been cases where liberties have sometimes been curtailed in the government. Importantly, though, when they are curtailed, part of the safeguards is that due process is applied. So it's not an arbitrary thing to just restrict speech, religion, whatnot. There are safeguards in place to make sure it's done for a good reason, in a narrow sense, and only for specific purposes, and not done broadly. All right. So first of all, let's get into talking about where the civil liberties are located in our founding documents. First of all, the Constitution. This was the subject of a previous lecture when we talked in detail about it. Maybe this isn't the Constitution itself as originally ratified isn't what we think of first when we think of civil liberties. Most would maybe say the Bill of Rights is where most of them are located, and they'd be correct. However, there are some civil liberties enshrined in the document itself, even if we don't consider the amendments that are added later on. In a general sense, we've mentioned separation of powers, checks and balances, which are there to limit overreach of the government, and such that if one branch decides it wants to do something that's counter to freedom or liberty or justice, other branches are there that can check those actions. And in that sense, just the structure of government and the relationship of power between these different branches in itself is a protection of civil liberty. So just the way the government functions and is designed in the Constitution. There are, though, some specific protections found in Article 1 of the Constitution. Notably, habeas corpus is found there in Article 1, Section 9, the right of people who are accused of committing crimes to hear their charges formally in court. This is also, though, a good example of how sometimes civil liberties can be suspended in times of crisis. For instance, during the Civil War, habeas corpus wasn't universally applied. You also find in Article 1, Section 9, protection against ex post facto laws, basically saying that Congress can't pass a law that says something is illegal after the fact. So if some act is committed by a person or a group, Congress can't make it illegal, after they've already committed it. You can only be prosecuted for criminal violations that were on the books before the action was done. Right. Of course, though, the Bill of Rights is where most of our protections of civil liberties are found in the Constitution. The Bill of Rights referring, of course, to the first 10 amendments, which were passed shortly after ratification of the Constitution. You recall from the Constitution lecture, the new document is ratified in 1789. The Bill of Rights is later passed and ratified in 1791, so just a few years difference there. And the first 8 amendments are where most of the specific civil liberties that we enjoy are laid out in the Bill of Rights. So here's a chart summarizing them. You can see a lot of them deal with freedom of expression, like speech, assembly, the press. Lots of them deal with rights of defendants. And then there are some miscellaneous provisions, like right to bear arms, protection against quartering of soldiers in your house, the takings clause, which prevents the government from taking your property without compensation. Interestingly, though, you also have the Ninth Amendment, which points out that just because we have a list of rights here, this is not an exhaustive list, basically. Just because something is not listed in the Bill of Rights in one of these amendments, the first 8, doesn't mean that the government can do away with it. So one of the criticisms of having this Bill of Rights in the first place, it was something suggested by the Anti-Federalists. One of the Federalist critiques was that by enumerating these rights, people may, at a later point in time, be able to come and say some other right that the people hold isn't actually applicable, isn't protected, because it's not in the Bill of Rights. And the Ninth Amendment is there just to say that isn't the case. There may be rights that are held by the people besides these that are listed here. And the 10th Amendment, we talked about this in the federalism lecture, where any power that isn't explicitly listed as being given to the federal government or denied to the states is left to the states. So this has less to do with civil liberties, but in some sense, by limiting the scope of what the federal government is allowed to do, the 10th Amendment is somewhat of a protection on civil liberties. All right. Important to note going forward before we get into a discussion of some of these specific liberties that we're going to talk about, it's really interesting to note that the application of the Bill of Rights and the liberties found therein changes dramatically throughout the nation's history. So originally, the Supreme Court holds that the Bill of Rights only applies to the federal government. And you can see why, given the language here, for instance, of the First Amendment, why this interpretation might have been the case. So the First Amendment says that Congress shall make no law abridging the freedom of speech, among other things, where Congress is interpreted as the Congress in Washington, D.C., the amendment doesn't say anything about states not being able to restrict freedom of speech, for instance. So as we go throughout history, the first 100+ years, the Bill of Rights is interpreted quite narrowly. It's restricting what Congress can do. In other words, in the federal government, they can't restrict freedom of speech, religion, things like this. But states are allowed to. As it turns out, though, given the political ideology which characterizes the United States throughout its history, it wasn't really the case that states would go out of their way and have really burdensome restrictions on speech or the press or whatnot. In fact, many states had their own Bill of Rights, which looked pretty similar to the Bill of Rights found in the nation's Constitution. However, moving forward a little bit into history, beginning in the first part of the 20th century, the Supreme Court starts to readjust how it's interpreting the Bill of Rights. And they start embarking on this doctrine known as incorporation, whereby specific parts of the Bill of Rights, when court cases concerning them come across the Supreme Court, they begin interpreting them as applying to the states as well. And the big change here is this due process clause, which comes about as a result of the 14th Amendment. It's part of that amendment that's passed in the wake of the Civil War. And part of what it does is it says that states cannot deprive people of life, liberty, and property without due process of the law. The key language there being that it explicitly mentions states and what they can and cannot do. In the Supreme Court, moving forward, starting in 1925 with Gitlow v. New York, they begin applying most of the civil liberties found in the Bill of Rights to the states as well. In other words, restricting what states can do in terms of freedom of speech, religion, and other things. One thing to note about incorporation that's important is it was done selectively on a case-by-case basis. It wasn't the case that one court proceeding came across the Supreme Court and then they decided all at once to say the entire Bill of Rights applies to the states. What would happen is they would get a court case, for instance, that applies to freedom of speech and say, okay, the protections of freedom of speech found in the First Amendment, they apply to the states. And then they'd get another case, for instance, that says it has to do with the Fourth Amendment, maybe in the rights to protections against unreasonable searches and seizures. They would say, okay, the Fourth Amendment now applies to the states as well as the federal government. So it was done on a really piecemeal basis, selective in nature, not total in nature. Another interesting aspect of incorporation is the Third Amendment is the only one that hasn't been incorporated. And you can imagine why this is the case. It pertains to the quartering of soldiers, which since the early 20th century, when incorporation started to come about, there really haven't been any issues with the federal government or state governments trying to quarter soldiers in people's home against their will. So it's just not a court case that has come across the Supreme Court's desk since then. And the last part of the Bill of Rights that was successfully incorporated was the Second Amendment. In 2010, McDonald v. Chicago, some of you, maybe if you were paying attention to politics back then, you can remember when this case was ruled upon. So this was just, because we're talking about selective incorporation, this was just the first case that came across the Supreme Court's desk dealing with the Second Amendment to where they wanted to incorporate it into the Bill of Rights. So if you look at things now, this is a handy chart. You don't have to really familiarize yourself with all these different court cases. It's just interesting that you can see the history here, starting from 1925. This actually doesn't even go up to the most recent, actually yes, here, 2010, McDonald v. Chicago. A pretty extensive process, and again, the only amendment that hasn't been incorporated yet, and again, the Third Amendment here. But now that we've talked about where these civil liberties are located in the Constitution and the Bill of Rights, and how their application has changed over time, let's get into some discussion about specific rights that we hold, and specifically how the Supreme Court has treated them. Starting with freedom of speech, so when we're talking of freedom of speech, this is basically the most cherished and most valued liberty that we hold in our political culture. Our way of life, our government doesn't work the way that we expect it to if people aren't allowed to say what they want to say. When speaking of potential restrictions on speech, they can take one of two different forms. The first being prior restraint, in other words, censorship of something before it's said, or punishment, on the other hand, of a statement that's deemed illegal after the fact. In general, the government hasn't really engaged in too much censorship or after-the-fact post-speech punishment. There are, of course, examples throughout our nation's history that we can think of, but overall, freedom of speech is generally well protected in our system. When talking about the cases where it's not protected, it's worth tracing back through time how the court has determined when this is the case and when it isn't the case. In other words, when the government passes a law or takes some action restricting speech or punishing people for saying a particular thing, how has the court handled that when it comes to them? How have they determined whether that's allowed or not allowed? We can begin going up to about the first part of the 20th century. Until this time, the court relied on what was known as the bad tendency standard. So, if the government did something to restrict speech or punish someone for saying something, the court would ask itself, does the speech in question support criminal action? So if something was illegal on the books, robbery, murder, something like this, and someone makes a statement, someone should be killed or whatever, if it was deemed to promote criminality, the court would generally allow that restriction. So this is somewhat of an easy standard for the government to justify. As we go forward in time, though, the standards that the Supreme Court places on restrictions of speech get more and more burdensome on the government. So beginning in 1919, this is when the bad tendency standard is replaced in Schenck v. United States. This is a famous court case where the clear and present danger standard is introduced. So instead of judging restrictions just based on whether the speech had the tendency to promote lawlessness, the government now was forced to demonstrate that the speech that it's punishing or preventing posed a clear and present danger. The famous phrase coming out of this court case, the decision, is that you can't shout fire in a crowded theater. I'm paraphrasing, but if you ever heard that phrase, that's where it comes from. The logic being, if you do shout fire falsely in a crowded theater, it obviously presents a clear danger, clear and present. So this is an instance of speech that can be prohibited by government and punished when it does occur. There's obviously a higher threshold for the government to meet than just the bad tendency standard. So going forward, in other words, the courts are placing more and more of a burden on the state or the federal government to present evidence demonstrating that basically their restrictions are valid and needed. Moving forward in time, a little bit more to 1951, there's another case that comes up that's worth talking about, Dennis v. United States, which alters the clear and present danger standard a little bit. So this was a court case that involves Dennis here. He is a leader of the Communist Party of the United States, and part of his doctrine, or in their published materials, was the suggestion that the government of the United States should be violently overthrown. And so applying the clear and present danger standard, this might not be an area of speech that could validly be prevented from government, right? I mean, just because someone publishes something saying we want the government overthrown, that doesn't really pose a clear and present danger, given that the Communist Party of the United States at this time wasn't really in any position to actually carry out on that threat or that desire. However, in this court case, the court introduces some new standards whereby the court doesn't just look at how probable the action in question is, it also looks at the degree of danger posed. So in this case, the court decides that maybe the probability of danger isn't very high, but the degree of threat posed by the overthrow of the national government is extremely high. So we're taking that into account as well, and they rule that this is a valid restriction of speech by the government to prevent the Communist Party from saying these things. So in this case, there's a bit of a counter trend in that the court expands the body of instances in which the federal government can restrict speech. However, going forward even more, we get into 1969. This is where the free speech protection as we know it today really takes hold. And in this case, the court reverses its previous decision in Dennis v. United States and holds that just abstract advocacy or calls for violence aren't enough to restrict speech. There has to be an actual demonstrated imminent lawless action that's being advanced by the speech. This even goes beyond the previous clear and present danger precedent. It basically says that danger isn't enough. You have to demonstrate, if you want to restrict speech or punish speech after the fact, that the speech was designed, intended to incite an imminent act of violence, lawlessness, whatever. So basically at this point, the burden shifts completely to the government in terms of justification. If they want to censor something, or if they want to punish someone after the fact for something that they said, there's an extremely high burden to demonstrate that what was said actually did constitute a call for imminent lawless action. However, it's also worth noting as we close the discussion on free speech that there are still some categories of speech that are restricted, sort of special cases that the court has separated from broader categories of speech. For instance, fighting words aren't protected speech, so if you say something to someone with the intention of inciting them to violence, that's not protected speech. You can be punished for that. Defamation, so libel, slander, the intentional publication or dissemination of knowingly false statements with the intent of defaming someone, that isn't protected speech. So if a newspaper publishes a story they know to be false beforehand, that's designed to smear someone, that's something that can be punished after the fact. Commercial speech, that's another special category. Saying something about your product, if you know it to be untrue, just with the intent of getting someone to buy your product where they otherwise might, that's not allowed. You can't say, for instance, if you're a jewelry salesman, you can't say a piece that you're selling is made of solid gold when in fact you know it's not. You have to be truthful in your advertising. And finally, obscenity. This is a complex subject matter. What constitutes obscenity is obviously very subjective, but there are restrictions that are allowed on obscenity in public spaces. It's just difficult sometimes to identify and justify what's considered obscene. Right, moving on from free speech, let's now get into another set of protections that's found in the First Amendment, freedom of religion. So specifically, this is what the First Amendment says about religion. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And this statement is most typically been parsed out into two different components. One, the Establishment Clause, which would be everything to the left of the comma, and then finally the Free Exercise Clause, which is to the right of the comma. So these are two different clauses that are basically for the bedrock of religious freedom in our country. Let's talk about both of them in order. So first of all, the Establishment Clause, as the wording says, what we just read, it's basically preventing the federal government forward in time, moving on to the state governments once incorporation takes effect, preventing them from establishing an official religion. And the interpretation of this clause has actually been broader than that in most cases, also preventing government from even treating one religion preferably, preventing them from doing anything that might spread a religion, or even anything that might promote religion over a state of non-religiousness. These are all the types of things that will be restricted under the Establishment Clause. The most notable court case as it pertains to the Establishment Clause is this one, Lemon v. Kurtzman. And this establishes a three-part test which the court then uses and applies to subsequent cases to determine whether a government action violates the Establishment Clause. And the test is three-pronged. First, does a law or action, whatever is in question, have some sort of secular purpose? It needs to in order not to violate the Establishment Clause. Second, is a primary effect to either advance or inhibit a religion. So these in conjunction are basically saying that there has to be a secular purpose, and the secular purpose has to be more prominent than any religious purpose. The primary effect has to be secular in nature. And third, does the law excessively entangle the government with religion. So basically, the court applies all three of these questions to whatever action is in question, whatever law or ruling, maybe by a lower court, has been made. They apply this test. And if any of the prongs is violated, any of these three standards, the Establishment Clause is said to be in violation, and that action or law is thrown out of the books. And there are a number of types of cases that come across the court in which the Establishment Clause is relevant. School prayer is really one prominent one. Court cases have ruled against school prayer and preventing it, saying that it is, in effect, promotion of a religion over non-religion, or maybe even a promotion of a specific religion in cases where school prayer is allowed or promoted in public schools, so that's not allowed. Private schools, of course, are different since they're not state-run. Public religious displays, this is another area where the Establishment Clause has sometimes resulted in restrictions. For instance, displays of the Ten Commandments outside of courthouses. There have been cases where those have been ordered to be taken down as a result of violating the Establishment Clause. And another interesting case, the Office of Faith-Based Initiatives. This was an office established in the executive branch by George W. Bush shortly into his term, which is basically there to assist faith-based groups and organizations in efforts to provide community assistance, relief, aid, things like this. And one of the criticisms of this office was that it violated the Establishment Clause because the government is working hand in hand with these faith-based religious groups. However, this gets taken to the Supreme Court, and the ruling here doesn't actually say that this office is consistent with the Establishment Clause, but the case gets thrown out basically because the people who are bringing the case to court don't have standing to sue, which is a term, if you don't know what it is already, we'll talk about when we get into the federal judiciary. But basically, it's allowed to continue, and it actually continues throughout Obama's term as well, even though the office is renamed. But just as is one interesting recent example of where the Establishment Clause becomes relevant in terms of what the government is and isn't allowed to do. All right, and so the other aspect of the First Amendment dealing with religion that we just mentioned is the Free Exercise Clause. So whereas the Establishment Clause is saying the government can't create an official state religion, the Free Exercise Clause is saying that the government can neither restrict religious practices among individuals. So people are free to worship whatever religion they want, whatever God they want, mostly in whatever way they wish to. And like the Establishment Clause, a relevant case comes in front of the court, Sherbert v. Werner, 1963. The background of this is that it involves a worker in South Carolina who quit her job because she didn't want to work on Saturdays. She was following a religion such that she was supposed to observe the Sabbath and not work on Saturdays. So she quits and files for unemployment benefits. However, the state denies her those benefits because they say she could have exercised the option to stick around, not quit the job, so she wasn't fired without cause, basically, so she's not eligible for unemployment. She says, this is a violation of my right to practice religion as I wish to, and the case eventually goes to the Supreme Court in Sherbert v. Werner, and they rule in her favor, saying that denying these unemployment benefits that are otherwise available to everyone on the grounds that she quit her job because of religious beliefs, this is in effect a restriction on the free practice of religion. And the Sherbert test that emerges out of this court case goes as follows. First, does the action, the law, policy, whatever we're talking about, does it impose a significant burden on religious exercise? So this is a pretty basic question that you have to ask at the forefront. Obviously, if the court finds that it doesn't burden religion, it's not going to be in violation of the Free Exercise Clause. The second component is maybe more interesting. First, is there a compelling government interest served by the law or policy? So is there a reason, a good reason why the law should be the law should be in place? For instance, is it a law promoting public health, public safety, something like this? Is there something that the government is doing for good reason to put the law in place? And finally, is there no alternative policy that could achieve the same end while avoiding the infringement on the practice of religion? So these two kind of go hand in hand, right? If there is an interest, the government also has to ask, is there any other way to achieve this goal without infringing on religion? A recent example, which many of you are probably familiar with if you followed politics back during 2014, Burwell v. Hobby Lobby. This court case emerges out of Obamacare and one of the Affordable Care Act. One of the effects of it is to require employers past a certain number of employees in their health plan to offer contraceptives. Hobby Lobby, they are a corporation privately owned, and the owners hold Christian beliefs that they say are violated by being forced to provide contraceptives to their employees. So this court case goes all the way up to the Supreme Court and reaches it in 2014. And what the court holds is that there is a compelling government interest at place here. We could, they make that assumption and say, yeah, providing contraceptives, that could be considered a compelling interest. However, there are less burdensome methods of achieving that interest. Instead of forcing the employer to provide the contraceptives through their health coverage, one less burdensome way to do that would have been just for the government to provide the contraceptives directly, for instance. So, in this case, the court rules in favor of Hobby Lobby on the grounds that this portion of the Affordable Care Act violated the Free Exercise Clause. And now that we've talked a little bit about speech, a little bit about freedom of religion, the final broad area of liberties that we're going to cover here deals with criminal procedure. So the Bill of Rights, in various places, has protections built in for people that are going through the process of being, accused of a crime, tried for a crime, convicted of a crime, and we'll talk about what these protections are. Important to note, though, that the scope of protections has changed really dramatically just in recent decades, as the Supreme Court has gone from a narrow interpretation of parts of the Bill of Rights to a really broad interpretation of what protections are entailed. Much of what we know maybe gets taken for granted. Things like Miranda warnings, right to counsel. These are protections that were only put in place recently as a result of Supreme Court rulings. In terms of the Bill of Rights, this chart sort of conveniently summarizes the different protections that are there. And if you're hearing fireworks in the background, forgive me, I'm recording this on New Year's Eve, so Happy New Year for all of you. But anyway, you notice that within the Bill of Rights, there are protections at pretty much every level of the system. When you're under investigation for a crime, if it gets to the point of being arrested, there are protections in place. When it goes to trial, there are certain ways that the trial has to proceed in order to ensure fairness and sound judgment when eventually you get to the ruling. And if it so happens that you're sentenced, there are guidelines on the Constitution preventing you from being sentenced in a cruel or unusual manner. So let's talk about, first, starting with what protections are available to you in the course of an investigation. As we know, the job of police, the police officers on the ground, detectives, prosecutors, their ultimate goal is to prevent crime and also to punish crime when it is committed. So the incentives of these jobs, because obviously they're occupied by humans, can sometimes lead to overzealousness on their part. The Fourth Amendment is there to protect against this. What it says is that you're protected against unreasonable searches and seizures. How this has been translated into a practical sense is basically that whenever you're being searched In order to do so, a detective or officer, whoever, has to have probable cause for undertaking the search, and usually this involves obtaining a warrant from a judge. So they'll bring forward whatever reasoning or evidence they have for wanting to conduct the search, and it'll typically have to be approved by a judge in order for it to be legal. So, what happens when this isn't the case? What happens if you're being investigated and the police officer or detective just kicks down your door with no warrant and starts searching your house? Well, typically this is going to be whatever evidence is found in such a search is going to be thrown out. In other words, not admitted as evidence in the course of a trial. So this is known as the exclusionary rule. It applies broadly. However, there are some exceptions. For instance, let's say the officer or detective, he doesn't kick down your door, but he enters your house thinking that he's obtained a proper warrant, but after the fact, it turns out that something procedurally went wrong, and the warrant isn't really valid. In this case, good faith exceptions can be made, so if the investigator uncovers some really key piece of evidence in the course of a search where he or she thought it was legal, but after the fact it turns out it's not, sometimes this can be admitted under a good faith exception. Another type of exception is inevitable discovery. This involves a case where a search is done illegally, and evidence is obtained in the course of this illegal search, but a court can rule that, if the investigators had gone through the proper channels, obtained the warrant or whatever is needed to search, this evidence would have been found anyway. It was inevitable that it would be discovered. In these cases, even though a search may be deemed illegal, this evidence can be admitted under this type of exception. And the background here is kind of interesting as far as where this emerges. A court case that leads to this precedent was a guy who had murdered someone, and he had started asserting his right to silence and not to be questioned. However, basically those investigating the case didn't respect his wishes not to be questioned in the absence of an attorney. And during the case of what turns out to be an illegal interrogation of the murder suspect, he gives up where he left the body of the victim. The investigators find it. However, the information leading to this discovery was illegal. So this case eventually goes to the Supreme Court to determine whether or not the evidence, the body and the evidence associated with it, can be admitted in the prosecution against this murderer. He's eventually convicted, and he wants this evidence thrown out on appeal. The court rules that even though maybe they found the body sooner as a result of the illegal interrogation, it would have been discovered inevitably anyway, and so it's still admissible. And this is where this type of exception originates, that case that I just described. All right, moving beyond the investigation phase, usually the next step, if someone is being investigated and there's enough evidence discovered against them, they'll typically be arrested and then brought to trial. And the Bill of Rights also provides a number of protections during this stage of the process. Most notably, if you've ever watched a crime drama on TV or the movies, you probably, if they were doing an authentic job of replicating an arrest scene, the officer reads the Miranda warnings. You have the right to remain silent. You have the right to an attorney. Anything you say can and will be used against you. Up until 1966, this was not something that arresting officers were required to inform suspects of. So up until then, you had these rights, the right to remain silent, the right to an attorney, for example, but you weren't necessarily required to be informed of them. So someone, maybe they never took POL102, so they don't know that the right to remain silent is found in the Constitution, the Bill of Rights. So, maybe they start talking to the police officers, or maybe they wouldn't have if they were informed of this right beforehand. So the Supreme Court eventually rules in Miranda v. Arizona that upon arresting someone, the arresting officer is required to inform them of these relevant rights. And so, this is a relatively recent development. We just mentioned the Fifth Amendment. This is the part of the Constitution that prevents you from having to incriminate yourself. You don't have to testify. If you're brought up on trial, you don't have to go up and subject yourself to questioning. You're allowed to remain silent. The Due Process Clause is found there. So, in other words, you can't be deprived of things by the government, whether we're talking about your life, liberty, or property, without due process. In other words, these processes that we're talking about to ensure fair and just procedures, they have to be followed. You can't be put on trial for the same thing twice. If you go on trial for a crime and you get acquitted, the government is not allowed to then try it again and put you back on trial for the same crime. So that's a protection found in the Fifth Amendment as well. Moving on to the Sixth Amendment, this is another one where the reinterpretation of the amendment changes its practical application relatively recently in Gideon v. Wainwright. So in the amendment, you find things like the right to a speedy trial, right to a jury trial, and also assistance by legal counsel. In terms of Gideon v. Wainwright, the question involves assistance by legal counsel and whether or not this is an affirmative right or just a protection against government interference. To put it differently, up until Gideon v. Wainwright, this clause in the amendment was interpreted just as saying, if you have the ability to provide yourself a lawyer, the government cannot prevent you from being represented by your lawyer. It wasn't interpreted in the way we think of it now, that the government has to provide you with counsel through a public defender. In this court case, the court rules that basically this is an affirmative right that you have, so the government at whatever level you're talking about, federal, state, local, if you're arrested and charged with a crime, whatever the arresting relevant government body is, they have to provide you with counsel. This is a right that you had in certain states prior to Gideon v. Wainwright, but it was up to states and localities as to whether or not they wanted to provide public defenders. This court case has the effect of expanding that right to apply uniformly throughout the country. All right. Lastly, when you are investigated, arrested, and put on trial, if you are convicted after all this happens, there are still protections found in the Bill of Rights as far as how the government can treat you in the punishment phase. Specifically in the Eighth Amendment, this part of the Bill of Rights prevents you from being sentenced to cruel and unusual punishments. So this would cover things like punishments that are way in excess of the crime. You can't generally have like a life sentence for shoplifting or things like this that are way out of balance with the severity of what you've done. Cruelty like torture, exotic sentences of death, things like this are prevented. Basically anything that's judged as inhumane. And probably the most frequent Eighth Amendment type of case that comes across the court system is the death penalty. So obviously there are plenty of people who would think that the death penalty in itself is cruel. So this is often something that courts have to decide on. And the holding of the Supreme Court at the moment is that the death penalty is allowed. However, there are, of course, many states that on their own have outlawed the death penalty, within their own state, which, they're free to do that. They're free to punish within the bounds of the Constitution, the Eighth Amendment violators of state law however they wish to. In terms of the Supreme Court, in their rulings, they have put some restrictions on the death penalty, though. So, for instance, cases of rape, if you want to punish rape with the death penalty in your state, you're not allowed to do that. The courts have ruled that it's in excess of the crime. In cases where you have someone on trial who's mentally handicapped or a minor at the time where, when they committed their crime, The death penalty isn't allowed there either. The application of it specifically to these groups of people. And also in terms of minors, the application of punishments of life sentences without parole. This has also been judged as cruel and unusual, specifically in the context of minors. So if you're above the age of 18, this is an allowed form of punishment by the courts. If you're lower than the age of 18, they've prevented it for those people. Okay, so that concludes the lecture on civil liberties, and I will see you all next time.